Good day, everyone. It is an absolutely beautiful Saturday afternoon here in the Shanty. Why am I in the Shanty on a Saturday, you might ask? Because we here at the Shanty do not rest in our effort to make sure that you have the timely human resources news that you need. Okay, I didn't believe that either. Actually, I got all my yard work done. It's a bit early to take a nap, so, here I am. Plus, last night, Judge Shapiro from the Court of Claims issued his opinion and order on the state of Michigan's motion for stay pending appeal in his overturning of the Paid Medical Leave Act and the minimum wage law. So I wanted to spend a minute talking to you about that because I know you are all anxious to hear that. Now we're going to do a little something different today. This is actually two Shanties in one. We're going to talk about Judge Shapiro's order, but we're also going to talk about the Michigan Supreme Court's decision regarding Elliott-Larsen and sexual orientation. And we'll get to that in a minute. All right, so what did Judge Shapiro do last night? Good news or bad news? Well, before you panic, it's good news. But the first thing Judge Shapiro did was he actually denied the stay. The state of Michigan asked for a stay pending appeal. And there's a 4-factor test that you have to go through. And the judge went through the 4-factor test. And he said, accordingly, a stay pending appeal is denied. And then in the very next sentence of a very short order, he granted the stay. No, I don't understand it either, but we're not going to look a gift horse in the mouth. Here's what you need to know. The implementation of the judge's order is stayed until February 19th, 2023. And I'm going to read this word for word from the judge's order. Despite defendant's failure to demonstrate entitlement to a stay pending appeal, the court finds that there are justified concerns regarding the ability of employers and the relevant state agencies to immediately accommodate the changes required by 218 PA 337 and 218 PA 338. For this reason, the court finds that it is in the public interest to stay the effect of the court's decision for a period of time equivalent to the time between the date of the legislature's adoption of 218 PA 337 and 338, i.e. September 5, 2018, through the effective date of those acts, i.e. March 29, 2019, a period of 205 days. Accordingly, the court grants a stay without bond for a period of 205 days, i.e. through February 19, 2023. Any further stays should be sought at the Court of Appeals and or the Supreme Court. So what does that mean? That means this order. That means the Earned Sick Time Act and the minimum wage law as it was going to be in effect had it not been amended by the legislature will not go into effect at least until February 19, 2023, unless an appellate court steps in and overturns this stay. So, you take a deep breath now. We don't have to be in compliance on Monday when we come in now, do we? With these statutes as they were originally adopted. We've got time. Now, look, just because you've got 205 days doesn't mean you should necessarily take 205 days. And I strongly encourage you to start to plan how you're going to implement these things. They may go into effect. Now, an appeals court might overturn this judge. The Supreme Court might overturn this judge, but they might not. So I would encourage you to continue to plan, but now we don't have to panic. We've got a built-in window to get our policies correct and get them in the right place. All right, I also told you we were going to talk about the Michigan Supreme Court's decision regarding the Elliott-Larsen Civil Rights Act and earned sick time. I got earned sick time on the brain. The Elliott-Larsen Civil Rights Act and sexual orientation. As you know, we put an e-alert out Friday. Just so you know what's going on here, I was on the road Friday, and I did a shanty to go along with that e-alert. but we had some technical difficulties. I had some technical difficulties. Those of you that know me know that I can barely turn this iPad on to record these things. Tech isn't my strong suit. So with that in mind, we're going to fade this video out and fade into a new video if I can figure out how to edit. And you can hear what I have to say about Elliott-Larsen Civil Rights Act. For those of you that read the e-bulletin and don't want to listen to it, you might want to listen to it because I'm talking about something that I think you should be aware of and you might want to think about doing with respect to a couple of your employment documents. So, with that said, fade right, unless what we're doing is fading left. See you next time. Hey everybody, welcome to the Shanty. I know what you're thinking. That is not the Shanty. And you're right, it's not the Shanty, but the Shanty's not on the road, but I'm on the road because I'm in our brand new, shiny, spanking new Midtown Detroit offices. And while we don't have the Woodstock poster or the octopus or the ship, let me show you what we do have. That. Yep. That's Comerica Park and Ford Field, and over here is the Rensen and Little Caesars. Not a bad view. It ain't the Shanty, but it's not a bad view. So what are we doing the Shanty on the road for? Why am I doing that? Well, I'm doing that because it's been a busy couple weeks in the Michigan courts. You know, the last Shanty we talked about the Court of Claims, reinstating the Earned Sick Time Act and overturning the Michigan Paid Medical Leave Act. And yesterday, the Michigan Supreme Court, in a case called Rouch World LLC versus the Michigan Department of Civil Rights, handed down its decision that sexual orientation is encompassed within the definition of sex for purposes of the Elliott-Larsen Civil Rights Act. Now, the case arose, first of all, it was an expedited hearing before the court, and the case arose when a same-sex couple filed a charge of discrimination with the Michigan Department of Civil Rights because they were denied the use of a venue for their wedding reception, to host their wedding reception. The venue denied them use of the venue because, according to the venue, they had a sincerely held religious belief that marriage is between one man and one woman, and therefore they wouldn't provide their venue for a same-sex couple. They filed a complaint with the Department of Civil Rights. The Department of Civil Rights then sued on behalf of the employees, and it went up to the Supreme Court on expedited review, and the Supreme Court heard one issue. They decided one issue and one issue only, and that is, as I said, is sexual orientation encompassed within the definition of sex for purposes of the Elliott-Larsen Civil Rights Act. Now, this might not sound unfamiliar to you. How's that for double negative? This might sound familiar to you. It might sound familiar to you because the United States Supreme Court has already addressed this issue under Title VII of the Civil Rights Act of 1964. In a case called Bostic, the Supreme Court of the United States held that not only sexual orientation, but gender identity is encompassed within the definition of sex for purposes of Title VII. And if you read Adam Ratliff is an associate in the firm, a brilliant associate in the firm, who wrote the really, really good e-alert that accompanies this podcast, you'll know that the Michigan Supreme Court followed largely the ruling or the reasoning of the Bostic Court when determining basically the same question under the Elliott-Larsen Civil Rights Act. So what did the court say? The court said that we conclude that discrimination on the basis of sexual orientation necessarily involves discrimination because of sex in violation of Elliott-Larsen. In so doing, we find persuasive Bostic's application of Title VII's but-for standard. While we are encouraged but not bound to consider persuasive Title VII federal case law, we find that Bostic offers a straightforward analysis of the plain meaning of analogous statutory language, and we agree with its reasoning. So basically what the court said was, look, we don't have to follow the U.S. Supreme Court. They were deciding whether Title VII meant this. We're deciding whether Elliott-Larsen means this. They're not the same, but they're similar enough that we're going to take the Supreme Court's reasoning and apply it to Elliott-Larsen and come up with basically the same result. All right, so then the court went on to say, a discriminator's choice to deny an individual the full and equal enjoyment of the goods services, facilities, privileges, advantages, or accommodations on the basis of that individual's sexual orientation is action that is dependent upon the individual's sex under Elliott-Larsen. Sexual orientation, says the court, is inextricably bound up with sex because a person's sexual orientation is generally determined by reference to their own sex. For example, said the court, attraction to females in a fellow female is considered homosexual, while the same trait in a male is considered heterosexual. The sex of the individual at issue is necessary to determine their sexual orientation. To discriminate on the basis of sexual orientation then also requires the discriminator to intentionally treat individuals differently because of their sex. So, why is this a big deal for you guys, employers here in Michigan? For the most part, most employers in Michigan, if you have more than 15 employees, you're already covered by Title VII, so Bostic already applies to you. So you've already been following this, and most of you aren't discriminating on the basis of sexual orientation anyway. So why is this a big deal for employers? Well, it's a big deal for one primary reason. And you should be thinking about this differently than you thought about the Bostic case for one primary reason. And that reason involves how long an employee has to sue you under these two different statutes. And why I want you to start thinking about it, and I want you to go look at a couple of things and come back to us if you need some changes to them. We're talking about the statute of limitations here, okay? So under Title VII, if you want to sue your employer under Title VII, if an employee wants to sue their employer, they are required, it is a prerequisite, that they file a charge of discrimination with either the EEOC or, for those employers in Michigan, the Michigan Department of Civil Rights. You have to file with one of those agencies. You only have 300 days as an employee to file that charge of discrimination. Now, 300 days seems like a long time, but in the world of statute of limitations, it's pretty short. After you file that charge of discrimination, the EEOC will make a determination and they will issue a right, often they will issue a right to sue letter. After you've been issued the right to sue letter, that employee has only 90 days in which to file a claim in federal court. So this is a pretty short, compressed period of time for an employee to take action against you if they want to sue you under Title VII. Under Elliott-Larsen, on the other hand, you have 3 years. You don't have to file with an agency. You can go straight to court, and you've got 3 years to file that lawsuit. Now, 3 years is a really long time to file a lawsuit. Evidence disappears, it gets destroyed, people move on to other jobs, they're not with you anymore, witnesses disappear or go away, we can't find them. So you don't want to, if you're going to be sued, you want to be sued as quickly as possible. You don't want it dragging out forever. One of the advantages we have under Michigan law is the Michigan courts have made it clear that by contract, an employer and an employee in Michigan can agree to shorten that 3-year statute of limitations, all the way down to 180 days. Now, that's as far as you can go. You can't go under 180 days, but down to 180 days. Well, how do you do that by contract? Well, the way we do it, the way we've done it is, first of all, we put a shortened statute of limitations, an agreement, in the job application. It's in that print at the end of the job application. If you have our job application, it should be in there unless somebody took it out. In other words, you have language in there that says, as an employee, if I take this job, sign this job application, I agree that if I'm going to sue you, I'll do it within 180 days. And the courts will enforce that agreement. The other place we like to put that is in handbook acknowledgments. Now, let me make this clear. Handbook acknowledgments, not in the body of the handbook. Remember what your handbook says. Your handbook says this is not a contract of employment. So you don't want to put this language necessarily in the body of the handbook. You want to put it in the handbook acknowledgement. You put it in bold print so it stands out and it's not stuck in the fine print of the acknowledgement. And you put something like, I agree by my signature below that if I come to work for this employee, I will, if I'm going to sue them, do it within 180 days. Now, obviously, that's off the top of my head. It's not very artful language, but you know what we're trying to get at here. In other words, we want to put language in there that protects you and that shortens that statute of limitations to as short as possible. Now, federal courts have said, look, you can't do that under Title VII, but you can do it under Elliott-Larsen. So that's why we're here. That's why we're here outside the Shanty. Hope you have a great weekend. You see, I got my Law Shanty T-shirt on, so we didn't completely leave the Law Shanty behind. And these are available in the gift shop. I'm kidding. There's no gift shop. There's no gift shop. Have a great weekend, and I'll see you next time.